Good afternoon, everyone. Welcome back for our afternoon session. I'm Professor Kathy Langto. I teach constitutional law here at Villanova, and I want to welcome you. The Ryan Center has allotted 300 seconds to me for the introduction here. I've just wasted 20 seconds, I think. And that certainly isn't enough for our extraordinary panelists for this afternoon. And so I would refer you to the biographies in our brochure. Our first session is going to feature first Professor Sam Zakharoff, who's the Bonnie and Richard Rice, should have checked that before, Professor of Constitutional Law at NYU, one of the pioneers of the law of political process, and his very illustrious list of publications is too numerous to mention. And we're happy to have a colleague from downtown Philadelphia, Tabitha Abu El-Haj, who is an assistant professor of law at Drexel University Law School with principal interest in First Amendment and election law, and she'll be commenting. After her response, we're going to have a 10-minute question and answer and short break. Then we resume promptly at 3:25. And we'll hear from Professor John McGinnis, who's a professor of law at Northwestern, a very prolific scholar in the area of constitutional law and international law. And responding to him will be Professor Tuan Samahan, my colleague, professor of law here at Villanova, who teaches constitutional law. It is the Constitution's birthday today, and of course we have been honoring the father of the Constitution, James Madison, and so in my remaining 2 minutes or so, I felt that I should give my own favorite quote from James Madison, which is an old chestnut, but nevertheless I think applicable today. And of course it is from Federalist Number 51, and I think has particular resonance when we think about campaign finance, political corruption, and the role of the court and of Congress and of the people with respect to choosing their own representatives. And we should know this one by heart, but if you have forgotten it, I will read it to you. What is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men, over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions. And the question before us, of course, is, well, we know that men are not angels, so that we need not debate, but the question is how much control was contemplated by the framers, what auxiliary precautions are permitted under the Constitution, and for that I turn to our esteemed panelists, beginning first with Professor Zakharoff. Please join me in welcoming him.
Thank you. Thank you for inviting me. This is intended as a celebratory moment. It's intended to follow Congress and its wisdom, deciding that all educational institutions not only should enjoy the privilege of celebrating the Constitution, but just to make it clear, must do so. And in the form of all obligatory, mandated, celebratory institutions, I feel the need to recoil a bit and to wonder what exactly does it mean to celebrate the Constitution, to celebrate a bunch of old guys finally getting out of Philadelphia, which I gather is what happened today, that they finally got out. And what is it that gives to this musty piece of parchment this kind of long trajectory, this reverence that we have for it, this civic religious quality to it. And so that's the question I want to pose. And when I first did one of these Constitution Day talks a couple of years ago, the topic at the time, which was the legacy of the New Deal Constitution, at least lent itself to something contemporary, at least lent itself to the idea of how does society go about transforming itself, how does it adapt to new circumstances, what is it about the constraints and the flexibility of this particular document which allowed the United States to emerge through the course of the 20th century a much different country than that which entered the 20th century, but nonetheless one recognizable in its fundamental institutions. That's something that I could understand, and today the question is more open-textured. It's celebrate the Constitution. And so I want to take up the issue of that's right here, an enduring blueprint. An enduring blueprint. Okay. So is the Constitution an enduring blueprint? And in addressing that question, I'll start by following the lead of Princeton political scientist Keith Whittington. Whittington tells us that there are two conceptions of constitutional law that unfortunately get run together. First is a conception that is familiar to lawyers, to law professors, to law students, and it's basically the world of case analysis, basically the world that Whittington describes as constitutional interpretation. How do we translate the Constitution's specific mandates, its text, its language, its structures, into the resolution of particular conflicts that come up, and sometimes between the executive and the Congress, sometimes between the states and the federal government, sometimes between the citizenry and any agency of government. Whittington offers another category, which he calls constitutional construction. And constitutional construction is the mechanisms by which the institutions of governance are created from this piece of parchment. And in the category of constitutional construction, we approach the Constitution differently. We ask not that which it mandates, not that which it has resolved already, but how the structures that it puts into place can be transformed, can be used to fill in constitutional voids. If you take up this challenge, the Constitution may be as important for the controversies and for the issues of the day, for what it leaves open or unaddressed, as for what it says. There are many parts of the Constitution which have an apparent precision to them. The president must be 35 years old. We know what that means. The congressional power to establish a capital district not exceeding 10 miles square, right? So it can be only 10 by 10 and even less if Virginia reneges on a deal. And it says that the Supreme Court shall have original jurisdiction in all cases involving ambassadors. That's actually pretty easy to understand once we know the term original jurisdiction. But that's turns out to be not all that interesting. And it turns out that there are major voids in our Constitution that have defined large parts of our national experience. And I want to give 3 examples, and the third one will lead into the main substance of the talk. So let me take the first example. Perhaps the single most consequential act taken by the government, and we could debate whether it was first, second, third, but it was in the top 10, let's say, in the early days, was to redefine the territorial reach of the United States. The Louisiana Purchase was a transformative event in American constitutional history. It was a transformative event in the nature of the country, what it looked like, what its aspirations were, what its capacity to act on the world stage would be. Now, the Constitution, oddly, makes no provision for this. The Constitution does not address the question of how you expand the territory of the United States. So that Article 4, Section 3 says, new states may be admitted by the Congress into this union. Okay, so we know that if they're going to become states, Congress has to act. We know that the states can't be formed within other states, within existing states, without their consent. We know that 2 states can't be joined together forcibly without their consent. That's something that's never come up. But after that, we don't really know very much. The Constitution tells us, Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. So it anticipates that we can have territory and that Congress will be in charge of regulating it, but still nothing about how you acquire territory. And so the Congress and the President confronted this situation where Napoleon was desperate for funds in a war effort that was not going well. He offered to sell half the American continent for $15 million. Jefferson confronted a hostile Federalist faction in Congress, which believed, from the rhetoric of the election of 1800, that he was a secret agent for the French. And it did not help matters that his first major act as president was to try to give most of the treasury to the French so they could conduct a war effort in exchange for swampland. But nonetheless, it seemed a good idea. So Jefferson tried to figure out what can be done to move on this deal. It was time limited. It seemed to be in the national interest. He was the president, so what could be done? So he turned to his attorney general and said, what are the legal powers here? The attorney general says there is no constitutional power to do anything. Great, that's good. So he turned to other advisors. The practice of shopping around the executive branch for lawyers willing to give conflicting opinions did not begin with the current administration or the last one. It goes way back. Jefferson shopped around and he concluded the following, and I quote from Jefferson. He says, "More difference of opinion seems to exist as to the matter of disposing of Louisiana than I had imagined possible." No one was willing to give him a clear line of legal authority to act. And yet it seemed that the Constitution would have been furthered, the constitutional purposes would have been furthered had he acted. So what did Jefferson do? Well, he went ahead and just did it, and then said to Congress, come along or pretend that you stand in the way of the expansion of the country. So this is a tremendous problem of the arrogation of power by a president. Now, this is not the first or the last time that the president has found himself in this position in the United States. And let me quote to you from one of our presidents. Strict observance of the written law is doubtless one of the high duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger are of higher obligation. To lose our country by a scrupulous adherence to the written law would be to lose the law itself, with life, liberty, and property, and all those who are enjoying them with us, thus absurdly sacrificing the end to the means. Now, for those of you who know American constitutional history, this sounds like the next person I'm going to turn to, Abraham Lincoln, writing on overriding Congress during the Civil War. In fact, this is Thomas Jefferson. This is the first president who had to confront what appeared to be an ultra-virus use of executive power, and he concluded quite simply and categorically, sometimes you just have to do it, right? Carl Schmitt did not invent this doctrine. So what did Jefferson do? He moved. He bought Louisiana, and then, without any major Supreme Court case ever to ratify this, the legality of the Louisiana Purchase, which came from the fact that we did it, then became the legal authority for the purchase of Alaska, for the annexation of Texas, for the acquisition of Florida, for the acquisitions from Mexico of Arizona, California, New Mexico, and Utah, ultimately for the acquisition of Hawaii, for the incorporation of Hawaii. So that's one example of, on a central issue of how you acquire territory, which the Constitution anticipates that there will be territory, there's a void. No discussion of how it is to be done. Let me give you another example, and this is one where our Constitution differs from virtually every democratic constitution, beginning with the Roman republics going forward. And that is, our Constitution fails to specify how emergency powers may be utilized. That was the basis of Viet Dinh's presentation this morning. It doesn't say how emergencies are declared. It doesn't say how long they will last. It doesn't recognize the range of emergency powers that may be necessary. It acknowledges that there will be emergencies, because in Article 1, which presumably details the powers of Congress, we are told that there are situations in which the writ of habeas corpus may be suspended during times of rebellion or times of invasion. That language appears in the Constitution. But the suspension of the writ of habeas corpus, if you try to array the entire powers that are necessary to deal with a foreign invasion, that would be really low down the list, right? The idea of how long can you hold somebody and to whom must you answer and what kind of federal court proceedings there will be once you've captured somebody would not be near the top of anyone's list. of the most important powers that have to be addressed in this moment. So it anticipates that there's emergency situations. It gives one example of a power that might be associated with it, but it doesn't say very much. So Lincoln finds himself confronted not just with rebellion or invasion, but with rebellion and invasion, and from within the country. And he concludes, and this is to quote Lincoln, that the Constitution itself is silent as to which of who is the exercise of this power. It's a weird formulation. Lincoln's usually more elegant, but anyway, is to exercise this power, and as the provision was plainly made for dangerous emergency, it cannot be believed the framers of the instrument intended that in every course to danger should run its course until Congress could be called together, the very assembling of which might be prevented, as was intended in this case by the rebellion. So what do you do when Congress is out of town? You can't bring them back because half of them are in rebellion, the other half can't cross Maryland safely. How do you go about protecting the Union? And the answer for Lincoln, like for Jefferson before him, was you act. And you act to fill the constitutional void. Hopefully you act in good faith. You turn to Congress after the fact, after you've let them sit far away from Washington for a few months and after you have dealt with the initial phases of the rebellion. And then you go to Congress and you say, this was necessary and I ask your approval and I want us to work together on this going forward. But again, you have a significant constitutional void on a critical function of government, maintaining the national security. Now, I want to turn to one other constitutional void, and I'm going to argue that in some sense this dwarfs all the others. And this is the one that I'm going to spend the rest of my time on. And that is that the Constitution has no textual commitment to democracy. And if there is one striking feature about our Constitution that dates it compared to all the constitutions that we see around the world that have emerged in the last couple hundred years, it is that our Constitution basically does not address the political process. There's no mention in our Constitution of political parties. There's no mention in our Constitution of how elections are run. There's no mention of the administration of election. There's no guarantee of the independence of election administration. And as we shall see in a moment, there's no discussion of how they are to be funded either. And this is not an accident. There is a sense in which the Constitution is a period of its own political compromise. Aristotle wrote that all constitutions necessarily reflect the political compromises of the time, or as we heard earlier today, constitutions have the charm and the wisdom of prenuptial agreements, and ours in this sense is no different. It is not an accident because we wanted to reserve as much power to the states on this issue because of the slave question, and so the idea of federal power over elections was deemed anathema to the security of the slave states. And so there are voids. It's not a complete void. There are things we can read into it. So for example, we have an apportionment clause, and the apportionment clause says that representation will be on the basis of population. So that indicates to us that there's some rudimentary sense of equality, what we later came to call one person, one vote, but some rudimentary sense of equality present in the Constitution that says that as the basic unit of aggregating governing power, the individual citizens have some stand in equal relation to each other. And the confirmation of that, paradoxically, is of course the 3/5 clause, which says how the slaves will be counted. So now we know that not only are persons the unit of counting, but sub-persons are unit of sub-counting, right? So a slave is deemed 3/5 of the person, so apportionment and representation in the Electoral College and all the rest is on that basis. We know that there are periodic elections in the Constitution, that the House is every 2 years, the President's every 4, that the Senate's every 6, and that we can construe means that they had a concept of rotation in office. They had some sense that these elections must be for something, and we heard much about that earlier today, that they have to be for something, and if they are for something, it must be to force some accountability so that rotation in office can be a way by which the citizenry checks the governance, and that may be a rudimentary sense of political legitimacy. But again, that's quite limited. Much has been written about the fact that this was a constitution against factions and that broke down almost immediately, certainly by 1796. The framers were out beating the constituencies, trying to organize national political slates. So we have some sense there, but again, it's all quite limited. So let me turn to the issue of campaign funding in the time I have left. I have 20 minutes left, roughly. Okay, in the time I have left. And then see how that fits in. Now, campaign funding is a horrible thing. It's a terrible thing. A couple of years ago, I edited a book with a colleague from England on campaign finance systems around the world, or what everybody else but us calls party funding systems. And we assembled essays from a dozen people, 8-10 different countries. And we were struck when the essays arrived, because every essay began as follows. In my country, fill in the blank, we have the worst campaign funding system in the world. And as the editor, you read this and you say, I think we're onto something. There's some problem here. So our Constitution doesn't specify the forms of democratic governance. It doesn't recognize political parties. It doesn't recognize how people will run for office. It doesn't recognize anything about the enterprise of the political process. For all Madison's talk about, you expand the domain and the risk of faction is smaller, and then you get more public's interest in the outcome. There's no discussion about how exactly do you expand the domain in a way that can allow for meaningful participation. How are they going to get there? Who's going to buy them a horse? Right? Who's going to print the leaflet? Who's going to get the word out that they're coming? And so one of the things that we do in this area, as in all others, is we try to reach for other principles that can guide us through the constitutional void. And the principle that does not work here is the one that worked for Jefferson and Lincoln, which is simply executive unilateralism, and then going to Congress to ratify what the executive has done. And so instead, we look at a constitution that has the following structure, which I will suggest to you, which is, assuming a democratic governance, here are the structures of how it's to be done. And then we say, okay, now let's fill in the first clause on assuming democratic governance, which is assumed by definition but not specified, and let's look at the second clause to tell us how to do the first clause. Now, as a logical construct, that can never work. But we have done this for 200 years. And for 200 years, we have tried to retrofit the aspects of constitutional law that have emerged out of other considerations, out of other questions, and push them back to try to use them to define the constitutional law of the political process. So what are the constitutional principles that could emerge within this? And here I want to suggest something that's actually quite heretical. And that is, I believe that we could have a large number of different constitutionally tolerable campaign financing regimes in the United States. I think that the regime that we have is a product of path dependence. I think that changing it has huge cost because it's a dislocation of the politics as we have them. But I think that had a different set of constitutional norms emerged, had a different set of funding norms emerged, that we would have a perfectly functioning democracy, perfectly well-functioning democracy that would just happen to look differently. So if we look at our most fraternal countries and look at how they do it, we notice things that are radically different. Australia, basically no rules. You want to contribute, you want to spend, go ahead. You know, good day. That's good. That's one system. It's easy to apply that system. It's real easy to apply that system. It has certain kinds of benefits. Canada. In our country, we say, as a result of constitutional law through Buckley v. Vallejo and the subsequent cases, including Citizens United, which I'll turn to in a second, in this country we say you can cap contributions because there's a risk of corruption there, but once the money's in your pocket, you can spend as much as you want because that's an expenditure and that's unregulated. Canada, they say, wait, that's backwards. They say you can contribute as much as you want, but you just can't spend it. Well, that sounds very odd to us, that you can go to wealthy people and get a whole lot of money from them, and then you just can't do anything with it. Britain is the most interesting. Britain has a system which informed much of our conception of freedom of expression, much of our conception of liberty. And in the British system, what you have is a system in which you can spend what you want, you can say what you want, except during the election period. As soon as elections are called, citizens shut up. As soon as the elections are called, the election period, only the political parties may speak. And they may speak not on television, they may speak not on the radio, they can only appear in publicly funded debates, of which there are a few. Now they get an hour of ad time also that they can divvy up. But nobody else can speak. And the candidates can't speak. If you're running for parliament, you're allowed to spend now up to £40,000, about $60,000. That's it. Only the parties speak. So there is a certain Mrs. Bowman who lives in London. And Mrs. Bowman is concerned that an issue that she considers very important, which is abortion, has not been part of public discourse in Britain. The parties take the position that abortion is a matter of personal conscience, and so they don't discuss it. The candidates have no capacity to express their views because they have so little money, so they don't discuss it. So believe it or not, in the country and the world most like ours, abortion is not part of national debate. Isn't that extraordinary? Mrs. Bowman thinks that people should at least know the position, such as it can be identified, of the people running for parliament from their constituency. So she wants to put out a flyer. She's old school. She wants to put out a piece of paper that just lists everybody running for parliament and what their known views on abortion are. No advocacy, flat out. She happens to be head of an anti-abortion group, but it's not an advocacy piece, it's just an information. She violates British law, which says that an individual citizen can only spend £5 on propagating his or her views during the election period. £5 is $8. It's about what it costs to go back and forth from the extreme ends of London on the tube. That's what you can spend. So, had she put out the flyer, she would have gone to jail. It's a criminal offense. Goes to the European Court of Human Rights. The European Court of Human Rights strikes us down, sends tremors through the English system. The British read the opinion and amend their laws, and they said, oh, we see, it was too small, so it's now £500. It means basically you have to be silent during the campaigns. Now, Britain is a healthy democracy. Had we evolved into the British system, I believe we would be a healthy democracy. But notice how shocking it is to our perceived sense of constitutional entitlements as they've emerged to contemplate a British system. So Mrs. Bowman in our country could spend whatever she can raise. Apparently, she can spend whatever she can raise unless she gets some money from a corporation or a trade union. Because one of the effects of the Bipartisan Campaign Reform Act was to create for the first time in the United States something really interesting. And this was a feature that the Supreme Court did not address in the McConnell case where they held BICRA, the Bipartisan Campaign Reform Act, McCain-Feingold, but is the biggest innovation, which is BICRA introduced the election period into the United States. Now, in parliamentary systems, the election period is an organic thing. It happens when you dissolve parliament and declare new elections. In the United States, it's just arbitrary. It's a month and 2 months, depending upon whether it's a primary or the general election. But the fact of getting some money to a corporation for a group that is as unifocal in its ideology, that is the Citizens United group, as Mrs. Bowman is in Britain, in the United States is actually quite a bit more shocking. And so we then have to ask, how does this fit in, not within our democratic structures, because our democratic structures, as I've suggested, I believe, could accommodate many different systems. But how does it fit in within a constitutional tradition that we have evolved to fill in this void? Well, when it was first argued in the Supreme Court last year, the statute in question addresses only broadcasting. And it's not even clear that it fell within broadcasting because it was pay-per-view, because they didn't have any money, so they weren't actually going to broadcast it. You had to call it into your home, as it were. They, assuming that it applied, the Supreme Court asked the Deputy Solicitor General, how does this work? What's the bounds of government power? What if she were putting out a book, right? And she'd gotten some corporate money, and the statute said books also. Could we ban books in the United States? The Solicitor General says absolutely. Absolutely. That didn't sit well. As a matter of advocacy, one can have second thoughts about that. When you ask the question, can you ban books, you know deep down inside, if you're arguing a First Amendment style case, the answer is no. Right? The answer is no. At the very least, you say, oh, my time is up. But you do not answer yes. So that prompted the second argument. And let me just give you a sense of what's in the background. Because Citizens United not only wanted to put out this stupid movie, Hillary the Movie, right? One waits for the DVD and all the other accessory products that are going to come with this. But they not only put that, they wanted to put out a flyer that says, download or go to pay-per-view and get Hillary the Movie. It tells all the truth about Hillary. She's horrible. She's running for president. She's bad. This is about the person running for president. Right? Let's keep that in mind. So they submit this to the Federal Election Commission. They say, we want to put out this flyer. We're afraid we've gotten some money from a corporation. We're afraid that it may be violative in some fashion. And they're told, okay, don't put it out. We don't give you prior approval. We'll get back to you. They get back to Citizens United 8 months later. 8 months later is March of 2009. Now, there's a view among, I'm not a political scientist, but some political scientists believe that if you want to influence the outcome of elections, it's better to speak before the election than after. So you may have some sense here that there is a chilling effect. Right? So what do we do about that? Well, we try to fit in this into our constitutional doctrines, our prior constitutional doctrines. And that's dominated by Buckley versus Vallejo, a 30-year-old case at this point. And Buckley versus Vallejo is what set up this world that contributions, you have to worry about corruption, expenditures you don't, and therefore one is protected and one is not. And I think that what Buckley versus Vallejo tried to do is to capture from the Constitution, and it may have done this poorly, but it tried to capture from the Constitution two central themes that have come to dominate our constitutional jurisprudence, and then to read them back into what should be the constitutional law of democratic governance. And the two are, and they are the dominant themes of constitutional law of the 20th century. They are liberty and equality. And the divide between contributions and expenditures does not hold up well in practice. But it seems to correspond to the idea that when you have money and you want to say something, and money is obviously necessary to say something. It's not speech, it is true, but Richard Briffault of Columbia Law School had this wonderful line at a conference we got together. He said, it's not really speech as such, but he says, it's pretty speechy. And because you need it to be able to speak in the modern world. You needed it in Madison's era to be able to speak. So you need, it's some kind of speech, and at that point the liberty side kicks in. On the first side, where there's the capacity the court tells us, on the contribution side, there's the capacity for corruption. Maybe that's where the equality side leads in. Maybe there is a sense that when people have disproportionate influence going in, that somehow there is a corruption of something. And that corruption seems to violate the notion that we all stand as one, as equals before the government. So that's the line that's been drawn, and that's why you get the technical distinctions in Citizens United, that these are independent expenditures, they are not contributions, there's not coordination. I can defend parts of the opinion, and you get the very extravagant language about corporations. But let me say two last things about Citizens United. The first is about corporations. And this is the most extravagant part of the opinion, that particularly Justice Scalia's opinion, where he says that the United States was founded as a corporation, it was built by people who were really private corporations who hadn't yet been incorporated, it was designed and devoted to corporations and all. That's ridiculous. It's much too extravagant, and you didn't need it. But the funny thing about corporations is that in most states in the country, they actually do have the right to participate in political processes, and they don't want to. Because when corporations want something from government, it turns out elections are a very noisy arena in which the signals get very mixed up. When they want something from government, you know what they do? They go to government directly. That's why there's K Street in Washington. When they go into the electoral arena, bad things happen. Target just wanted to give money to some pro-business guy running for governor of Minnesota. He turns out to be some anti-gay activist, and now they've got all these people protesting their stores around the country, and now it's going to cost them a lot more than the $150,000 they gave to this guy to buy off the protests that follow. Most corporations not only don't want to, but we have the evidence that they don't give money. It's not really the way they deal with government. But more problematic than this is that if we're worried about corruption, what kind of sense of the government process must we have in order to tease out the concept of corruption? And so after corruption was identified by Buckley v. Vallejo as the compelling governmental interest, all of a sudden we got this flurry of writing about corruption. So corruption was politicians lining their pocket, and then the question, well, why isn't that bribery? Why isn't that already addressed through the laws? On the other hand, we had Justice Marshall in the Austin case saying corruption is any distortion of the political process that's caused by differences in wealth among the population. Well, if it's that broad, then we've deemed any privately funded system of campaigns to be unconstitutional, and then corruption just means a different outcome in the elections against that which a court could determine should have obtained in the absence of that corruption. Extraordinary. Or maybe corruption means something else. And in the paper I have forthcoming that I'm not going to really get into, I suggest that really if you go back, there is a lurking sense that corruption means something. And it means an undermining of the purpose of government. And we have always wanted government to be about the provision of public goods. We understand that private initiative has worked well and continues to work well in the provision of most of the wants and services that people need. But there are some things, and you start with clean air and clean water and military defense and national parks and so forth, that it's very difficult for private enterprise to generate a profit from. And then there comes a problem, which is that government officials may become self-interested. They may start seeing the process of being governors as an opportunity to continue their office holding. And they may start to create larger and larger functions of government so that they can contribute partial returns to parts of the population, whether it's extravagant pensions that can no longer be paid, or whether it's cotton subsidies that are deemed illegal by the WTO, or whether it's all sorts of things to particularized interests that all of a sudden reward government for increasing the size of government in order to have funds to reward private constituencies. And that's a theory that political scientists refer to as clientelism. And clientelism is the death of democracy. And the odd thing is it's hard to tell what's going on at any given point, because when we look at many third world countries that have tried democracy but don't have civil society institutions, don't have traditions of trust, don't have political parties, you see that the state starts to expand and expand and expand very quickly, and there's a lot of side deals. And people can only prosper in the society by connection to the state. And then you see that the state kills society. So you have strong state, weak civil society. I think the framers' ideas didn't hold up because they had this idea that they had this notion that there was just society down here and the state up here. And the divisions within the state, the ambition versus ambition, running against ambition at the top, would somehow prevent there being a concentration of power, and then the citizens en masse would interact with the state. That failed. And what we have in society, by the time Tocqueville came to the United States, what he was struck by was the flourishing and the creativity and the dynamism of the civil society institutions in the United States, be it the political parties, be it the churches, be it the civic associations, the trade associations, all that range of things. And we have traditionally in this country had strong civil society institutions and a relatively weak state. The change in the world has pushed us to have a stronger and stronger state. And the question is whether we can address that in part, campaign finance laws perhaps through the lobbying laws, but recognize that this creates a different kind of danger which was not present before. My sense is that we will not get at this through abstract appeals to liberty and equality and other such doctrines which were forged to address a very different set of questions. It has speech components to it, but it's not the nightstick of the policeman beating the protester over the head. It has equality concerns to it, but it's not people being denied the franchise because they're women or they're blacks or something of this sort. So 2 final points to conclude. The first is, a lot of my writing, when I started as an academic, was going after a bunch of Supreme Court opinions that to my mind made no sense. And some of my 3 favorites were Bakke, right? You can take race into account, but you can't let it make a difference. What? Why else would you do it? Buckley, you can spend as much as you want, you just can't raise it. What? How do I do that? This is what Vince Blasio did. You spend all your time trying to raise it at that point because you can only raise it in little amounts, and it's an arms race anyway, and there's no expenditure at the top, no expenditure limit at the top. And the other one was Shaw versus Reno, which is kind of like Bakke, which was you can take race into account in the distribution of political opportunity, you just can't let it make a racially apparent difference. And you say, come again. How does that work? And what I have concluded, and maybe this is the same aging process that Vince was talking about, what I've concluded is that I've come to respect these 3 opinions a great deal. Because all 3 of these opinions, in my view, address a structural problem in our democracy. They address problems of maldistribution of resources that government has to have some role in, but can't have the exclusive role in. And they recognize they are temporizing a strategy to try to find an accommodation that's tolerable within our system, given the constitutional voids we face. So in conclusion, when you view the Constitution, this enduring blueprint, as a blueprint, I was going to use framework in my notes, but now I say blueprint, as a blueprint for democratic governance, it doesn't hold up very well. It has huge voids. We had a huge crisis immediately in 1800 because for all the specificity of how to elect the president, they got it wrong. On top of it, they screwed it up. It wasn't just badly written, it was bad. And so what we end up with in the system of constitutional governance that we have is give and take and sort of grudgingly moving our way toward an accommodation with structural imperfections in the document. The judicial role, which is crafted through the visible cases, is part, I think, of a multi-century and multi-level effort to use the Constitution to buttress democracy. The odd thing about this effort is that the Constitution can fairly be read to assume democratic governance and then set the means for its implementation. Sometimes, as I've tried to suggest this afternoon, the task is to fill in the priors. Thank you.
Can you hear me? I'm not sure whether this mic is right. Yes. Okay, good. So it's a pleasure to be asked to discuss Professor Issacharoff's paper, and one of the things that I enjoy about it is his pragmatism and sort of this acceptance that the Constitution has these voids. And so there's the debate about the Constitution has ambiguities and how you fill those in, and the debate and putting on the table that there really are these voids, and the voids lead to pragmatism. And I do agree at bottom with Professor Issacharoff that the plan was always pragmatic, and the blueprint was always anticipated to need to be modified. So the Jeffersonian, purchase Louisiana, go ahead. And the sort of rebellion example, I think, are really good examples of that. And so what I take, and I think is a valuable lesson out of this conversation, is that we have to recognize that the Constitution is silent and has voids, and there has to be a pragmatism in making it functional. And I am at heart a pragmatist. And then I reach campaign finance, and I am deeply discouraged, and I hate campaign finance because I think there are some voids we actually can't fill in this pragmatic way, and be faithful not just to the text, like to the words of the First Amendment, but be faithful to the sort of core liberalism that is in our Constitution. So I guess I want to talk a little bit about that. So what I would say is, while in general I'm pro-pragmatism, on the question of campaign finance, I'm skeptical that can resolve the issue. And that skepticism, I think, is broader. So first let me say a little bit about what I see as the dilemma of campaign finance and how it feeds into sort of a core liberal commitment. So the dilemma, as I think Professor Issacharoff would agree and posits, is on the one hand, we need to regulate spending at the moment in our contemporary democracy. And we need it for the reasons that both Justice Stevens articulates and Professor Issacharoff articulates, which are about sort of corruption in the political process. And I think Professor Issacharoff pushes that further than Justice Stevens in saying it may not be about individual legislators being corrupted, but it is somehow there is a distortion in the political process that requires some amount of fixing. That to get publicly regarding legislation, we might need to deal in some way, and I don't know which way, with the role of money. And on the other hand, as I think, on the other hand, what I would say is meaningful campaign finance reforms are guaranteed to come up against the First Amendment as it's been interpreted. And I want to push further and say sort of the core logic of the First Amendment is a core liberalism, and that there's no way out of that. So I think Justice Stevens is surely wrong, unfortunately. And this is why I hate talking about campaign finance, when he says that the majority's premise that the First Amendment bars regulatory distinctions based on a speaker's identity, including corporations, is nothing more than a glittering generality, right? Because I think that's the core of the liberalism of the First Amendment, is that you can't distinguish between speakers or between viewpoints. So if you think about a family, right, you have a kid who taunts the other kid at the table, and you're not going to let that go. But, or you have a kid who interrupts all the time or takes too much time at a family, and you say, oh, John, could you please let your sister tell us about her day? But the First Amendment puts that off the table when it comes to the government vis-a-vis political actors, right? And so what Justice Stevens says is, as to this claim that the majority makes, he says, while that glittering generality has rhetorical appeal, it's not a correct statement of the law. And I guess what I would like to say is it was probably right that that was not a correct statement of the law, but the law of campaign finance was neither coherent nor satisfying in a profound way, and that it has been a series of pragmatic adjustments meant to avoid confronting the central dilemma. And I think that we have to give the majority credit for facing that central dilemma. So how would I put it? I would say, campaign finance is desirable and unconstitutional. And now all of the conservatives in the room are like, great. And but now you're going to be disappointed, because the next thing I'm going to say is, but what I want to put on the table, and mostly for provocation's purposes, is the possibility that actually the First Amendment is wrong, that the First Amendment is the problem, and that it's the problem of liberalism. So let me define liberalism and then explain. So, the classic liberal constitution, right? The law requires formal equality, right? So the statement is, the law in its majestic equity, this is France, Anatole, France, forbids the rich as well as the poor to sleep under the bridge. And so we're very pleased with that formal equality of the law. But the downside of liberalism is because we're so focused on the state giving everybody equality and checking the possibility of the state transgressing individual rights, that the liberal constitution don't do that much to consider the ways that inequity are created by private citizens in the marketplace or in private racial discrimination or gender discrimination. So the liberalism focuses on concentrations of state power, but they don't worry about private power or the way that private power interferes with equality in fact or freedom in fact. So when Professor Issacharoff says we have these both liberty and equality in the Constitution, I would say we have liberty and we have formal equality, but we don't necessarily have in the liberal Constitution a substantive view of equality necessarily. And so in the First Amendment context, I think one issue, especially in campaign, is the possibility that the First Amendment's liberalism perversely protects the gross material inequality at the heart of American society. So that's when I say potentially the problem is with the First Amendment. It's not so much saying, oh, let's throw out liberalism, but it's saying we should recognize that one cost of liberalism is the possibility that the law protects inequality, that the First Amendment protects inequality in the real world. And so I might say distortion isn't the problem. It's not that campaign finance distorts the conversation. It's that the First Amendment translates the actual inequalities in the world directly into our political sphere. It allows those to be perfectly reflected in politics. And until today, I have mostly felt like there was no real way to get around it. And Professor Issacharoff, I think, offers maybe, although I'm still unsure, some hope. But before I can talk about why I think there's some hope, I feel I should say at this point, Professor Miller is probably saying, how did you invite such an irreverent and un-American person to come talk about the Constitution? And I would like to thank Professor, this has been my anxiety, how am I going to say what I actually think, which is the First Amendment is got some problems. And so I want to thank Professor Issacharoff for being irreverent with me, although for different reasons on sort of not the document itself, and for putting me in good company in a way with Presidents Jefferson and Lincoln, because until that point I was just going to say, yes, I am slightly irreverent about this. On the un-American front, here we've had Benjamin Franklin on the board part of capitalism. Should we really worry about inequalities and wealth? Isn't that potentially un-American? And on that, I actually feel in good standing with Thomas Jefferson and Teddy Roosevelt, and that tradition that really did worry about inequality in wealth. So I would say that liberalism doesn't maybe create space for that, but I do think there are American traditions. Professor Sheehan no doubt would say what they worried about wealth and corporations was different maybe than what I'm suggesting, because what they worried was that the law was actually enhancing economic inequality, and I agree. But I think there are, by the progressive period, there are some concerns that it might not, there might be a problem whether or not the government is creating that inequality. So anyway, so that's sort of where I see the central dilemma, and for the most part, the typical response to this is, and what I appreciate about Professor Isaacaroff's solution is it's more hopeful than the typical responses. So the typical responses are, and we've heard them here today, either corporations are different, and I think there's a plausible argument for that, but it doesn't actually avoid the dilemma, it just postpones the dilemma. So you might be able to salvage campaign finance reform for corporations, but you're not going to deal with the fundamental question of how this is going to work. Or the money talks approach, which we've also heard today. Money talks but is not speech is what I meant. And I think that sort of might say the First Amendment might have those problems, but it's not going to have those problems now because money isn't speech. And I think that Professor Isaacaroff's sort of and Professor Beeman making us realize we're in a really different political culture sort of makes that very not a response. But Professor Isaacaroff, I think, offers a third and provocative way of thinking about how maybe my diagnosis is wrong. And that is, I think, and you will correct me, I'm sure, is that you would say that the problem has nothing to do with inequalities in wealth necessarily, but inequalities in who is able to organize or not organize. So that the problem of corruption isn't that some people have a lot more money than other people. The problem of corruption is that some groups are better able to organize. Sometimes those are corporations, sometimes those are the ACLU or the Right to Life, and that that those groups as special interests can corrupt the political process by making it private regarding instead of public regarding. But it wouldn't have to do with these pre-existing ideas about wealth or inequality in the public sphere. And I think that's a very interesting possibility. So you might switch my hypothetical about one kid bullying another, which sounds like viewpoint discrimination, or to some speakers are just more articulate than other speakers in the public sphere. And so then does that solve, can the government create regulations sort of within the liberal paradigm that would allow it to create order if some speakers are more articulate, more well organized? And I guess the model might be more like the Roberts Rules of Order, right? You can have a rule that says any given speaker can only speak twice, right? Does that pose the same kinds of problems? And I'm not sure, actually, whether I think that that solves it, whether to once it's decoupled from inequality and some sort of normative concerns about equality, whether you get further. So, anyways, those were my thoughts on that issue, and I will look forward to Q&A. Thank you.
We have 10 minutes for questions, so please feel free. Or I'll call on you. Actually, did you want to respond? Oh, go ahead.
Just one comparative point, I suppose, or questions. One of the reasons why campaign finance legislation is such a big bleeping deal here is it's got to do with other structures, right? If we had a parliamentary system, if we had robust party discipline, if we had, heaven help us, compulsory voting, right, it wouldn't be such a big bleeping deal. And I mean, those are all conditions that pertain in Australia. So I think there's a larger set of structures here, which we might think about as constitutional if we weren't wedded to the narrow American public law model of, well, there's constitutional law, and heaven forfend that we think of, for example, administrative law as part of constitutional law. But I just think that gives you an interesting perspective. I love the idea that the First Amendment is a problem, I have to say, but I just thought about that.
Well, the comparative point is very difficult because Australia also has large crocodiles.
Dingoes that eat babies.
I don't know at what point Bolsonaro runs so quickly. It is certainly the case that parliamentary systems, particularly party list systems, take pressure off the individual candidates. It is a fact of American life that we have more elected offices than any other country by a factor of a gazillion. It is a problem that we don't have political parties. But let me give you an example that I came upon in dealing with Western Europe in particular. Western Europe has very liberal campaign funding rules, and the reason for it is that basically the socialist and communist parties were funded by the trade unions that they were affiliated with, and the Christian Democrats were funded by the small business associations. And that's how they funded it, and that's how they operate, and that's been post-war politics in Western Europe. Then something interesting happens, and the causal claims are complicated. Robert Putnam has many theories about this, but basically what happens is that the mass-based parties cease to be mass-based. And then they come up with a solution. And the solution is, it is improper in a good liberal society to have privately funded campaigns. What we need is public funding. And we give public funding on the basis of past electoral performance. Gee, how did they come up with that? They can't raise the money privately. They're in the government, and now they say the government should be our bankroll. You don't have to be deeply steeped in public choice theory to think that there may be some self-regarding quality. So it turns out that there are distortions from every single one of these systems. I think that Americans will think it great if they knew that you could not get on the internet and take out a web page, set up a web page to say that the local people are slime for whatever reason. We would be horrified. We'd be absolutely horrified. So, yeah, it's part of the deep structure. And that's why I began this by saying, I think, and this is something that I was colleagues with Vince for 5 years at Columbia, 6 years, and it's something I've taken from him, that when you try to tease out, what do you call it, the First Amendment tradition, First Amendment? What's the name of your course?
Oh, ideas of the First Amendment.
When you tease out the ideas of the First Amendment, which is what Vince has been telling me about for years, and you go back and you look at Milton, and you look at Mill, and you look at the kind of intellectual underpinnings of our system, what you find is that there are many political systems that could basically satisfy them. Brits had the same exact foundation as we did, basically, and they came up with a significantly different system. I think that many such systems are tolerable within this First Amendment tradition, this liberty of expression tradition. Unfortunately, they all have major institutional failings and major institutional gaps. And I was just in Australia. There's a lot of pressure for reform of the campaign finance system in Australia right now.
Please. A couple questions. One is, if you think the First Amendment is problematic, let me just flip the question a little bit. What is it that, not what is problematic, but what is it that you want to achieve? Is it equal speech? Does that seem more like fairness? That seems to be the examples you were pointing to of the, at the dinner table and so on, and the question of one person being more articulate than the other. Do we want to level that out somehow? What is it we're trying to achieve that would be better than the First Amendment? That's one question. Second question, maybe Professor Blasi wants to jump in here. what do you think ties together the various parts of the First Amendment? Is there something that ties together speech, press, assembly, freedom of religion, and so on? And if so, would that be conscience? And further, if it is, because Madison seems to point to that, is it dangerous to tinker with restrictions because these could affect other aspects of the First Amendment, including freedom of conscience?
Well, on the second one, I've always thought that would hold them together with semicolons, but I think that there's interesting work being done by a young guy in Chicago, El-Haj, on trying to view the collision clauses through the same prism that I and some of my colleagues have been trying to import as law of democracy thoughts of how do you view the expression and assembly clauses. I think that there is a deeper theory there. I think it would take us astray here, but I think that there is a zone of autonomy and self-governance that runs through this all. I'll turn it over to Tabitha, but let me just think one last point. When Austin versus the Michigan Chamber of Commerce was in 1990, which was the one big attempt to read a lot of the equality values or the anti-distortion values into the campaign finance law of the First Amendment, a former colleague of mine from University of Texas, Scott Poe, wrote a piece saying, if it's equality of wealth that we're after, campaign finance in the First Amendment seems like a very peculiar way to go about achieving it. I mean, the fundamental constitutional premise is equality of wealth. Campaign finance still seems a very silly place to go after it. And I would argue that if equality of access to the government was really concerned about the distortion of the political process, unfortunately, campaign finance is the one area that we can regulate. We have no idea how to regulate lobbying. We have no idea how to regulate other forms of access. And so we go after, like drunks looking for the car keys under the streetlight. We know that that's there, and we've got a lot of cases, so let's just run with that.
So I think what I want from the First Amendment, it was not so much what I was trying to get at, but what the people who would like the anti-distortion principle to be valid are looking for. And I think that what they're suggesting is they would like the public sphere to look like a dinner table or a faculty meeting or sort of a faculty meeting before I went to faculty meetings. But a deliberative place where everybody had equal voices. And I think what I was really trying to suggest is that is A, not possible by the First Amendment, but B, an odd hope given how likely is that deliberative, equitable, sort of virtuous, which, I aspire to normatively likely to happen given the realities of inequality in our outside of the political sphere. And I don't know if that really responds to
Here's the problem that we have. I am ignorant, and I'll lead a chant that we can all participate in about how ignorant we are. I go vote, I have no goddamn idea what is going on. Most of the people on the ballot I've never heard of. When they're ballot initiatives on one of those states, I have no idea what it's about. I have no way of knowing whether this is a good construction project. I need people to educate me. I don't want everybody having an equal voice at the table. I want the main players to educate me, to be able to educate me. And what you need for that is competitive politics. You need two people who are locked in battle and who have to tell me what's wrong. It's just the same way that when I go into a store and I know nothing about the product, I hope that there are two stores near each other so the two merchants will educate me about why they're better than the other one. That's politics. Unfortunately, the leveling impulses of everybody around the dinner table, everybody getting the same quantum speech and so forth, doesn't work because I don't want to hear equality from a lot of other uninformed people. You all look like nice people. I don't care what you have to say. I want people who actually know something to speak to. And the problem is that you have to go at this structurally, this kind of bottom-up individual equality point does not capture the vibrancy of modern mass politics. And unfortunately, money is the lubricant of that politics. So you have to worry about how to get money into the system. The best thing BICRA did, it had one great feature. It changed one thing that radically altered politics. It raised the contribution limits, doubled them for individual candidates, quadrupled them for parties. You know what that meant? That meant Barack Obama, a black man, could run for president with $800 million in the bank. Because the internet reduced the transaction cost of raising money, and you could actually give money. So he got 4 million different people to give him money. Small donors, but the money came in big chunks also. It was easier to raise money, and that was a good election. I mean, I was a lawyer for Obama, so it was, I think it was a good election in many ways, but it was a good election because it was dominated by the parties, by the candidates. They were relatively well-heeled, although McCain did not have a lot of money, he had public money. But it had the quality of educating us about what was at stake there. I think that's the most important. I think that this idea that we all are equal speakers just misunderstands the nature of political enterprise.
I hate to stop, but it's 3:25, and so I want to thank our panelists.